cite to you paragraphs 209 and 210 of the Supreme Court decision. It stopped at 208, I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry you're involved in, extends, the court when conducting this inquiry should bear in mind the unlimited reliefs contemplated under Article 23. No, that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubts, the court should now feel comfortable. My Lord, during the break, I inquired for my learned friend, Mr. Tiankolo, a very good friend of mine, and I asked him, Dr. Tiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my Lord?
Yes. You want to hear?
When I asked him, by what authority? He told me, by a conservatory order. And so, my Lord, this court can give conservatory orders against impeachment. The conservatory order we're speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August 2024, in petition E429 of 2024. Let me come to the other case, the Kisii Governor's case. My Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that that matter would come before Justice Okwan, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32 of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Moraki do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirela conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. Now, allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both of the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petition more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wengi Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. A lot of other cases we agree with, cited by the National Assembly's Gitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you've preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days, all the three chains of Kenyan's court, when required, have risen to the occasion. BBI did not last the 5 years my friend Mr. Gianconi spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Gideon Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Gienda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petition has not pleaded for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Kiankolu bases his preliminary objection on that point. He says that you should not touch this dispute because you will not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that, what would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IEBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed to reconstitute the IEBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy or conservatory orders in his and his client's favor. My Lord, a party cannot benefit from their own wrongdoing. That fact of vacancy in the IEBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners. My Lord.
Are there any pending litigation on the IEBC?
There are, yes, my Lord,
Yeah.
but this order has not been stayed, it has not been appealed.
That's all.
Yes, my Lord. My Lord, there's a case that we did with my good friend Mr. Adrian Kamoda. It's called Itumbi versus Law Society of Kenya, where Justice Omudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itumbi, through my good friend Adrian Kamoda Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask the Court of Appeal to vacate conservatory orders meant to preserve the status quo pending the hearing of the matter in court. We submit that the application to vacate made before you is an act of mischief. There's another case, my Lord, on this issue of vacating conservatory orders. This case was argued by my good friend Mr. Nyamudi when he was still on the good side of things. And Professor Gideon Migai was also in it. Those days, Nyamudi was a good guy. He had not joined the bad company of Mr. Gumbo, who is my friend. Lord, this is what the Court of Appeal said. The Court of Appeal said that...
Lord, he must be a bad guy if Gumbo is bad and his friend.
The Court of Appeal said, my Lord, that when weighty challenges have been placed before you, before a court, and the court has issued conservatory orders, one requires a very strong case to lift those conservatory orders. My Lord, a very strong case has not been made before you to lift the conservatory orders. Instead, a very strong case has been made to sustain and to affirm and to reiterate the conservatory orders. My Lord, I close with the issue of public interest. And again, thanks to the doctrine of precedence, you do not have to think too hard on this. In Attorney General versus Martini, shutting out 50 CISs whose appointment was questioned before the court, the Court of Appeal, my Lord, said that it would be no consolation to tell the Kenyan people that although service has been rendered, although unconstitutional service has been rendered, it's still service. The Court of Appeal said, my Lord, that service in violation of the Constitution is no service. And in a case that Professor Ojenda argued, the Ongo case, when
I didn't cite that.
I am citing it, well, I am citing it in the reply.
In response, but I thought on points of law, you refer to cases that have been cited by the other side.
No.
Can't pick up my case. I didn't have it.
My Lord, if he didn't argue it, he should have argued it. This is a point. My Lord, you are told about the public interest. the court of opinion no more.
I think you should respond to our case.
Yeah, I didn't argue that.
Because otherwise you also have the right
Yes,
to
I will.
Yeah, and we'll hear from much longer
We'll be
time.
back and forth. Yes, leave on.
Lord, if that should help true, my Lord, how would we have, for example, presented to you the Supreme Court President? Because the purpose of agenda as well, my Lord, is to distinguish and to tell the court points which the other side have concealed.
Well, say it, then we'll give him a right of
And
reply on that issue.
it's in our submissions. It is.
Do you accept that we'll give him a right of reply on that issue?
On this case, yes, my Lord, because it's in our submissions. The law case is in our submissions, my Lord, and they can distinguish it very shortly. My Lord, the court said, in short, that it is in the public interest to keep out a person if the validity of the appointment is questioned. He had wanted his client to assume office despite a court order to that appointment. And so, my Lord, the office here is a high state office. If Kithure Kindiki assumes office, he will make directives, he will make policies, he will commit omissions. My Lord, this court is yet to design a mechanism for reversing the policies, the decisions, the directives that you make. If at the end you find that the impeachment and the nomination were both unconstitutional, the Constitution would have been irreparably violated. And my Lord, I close on the point that this case is arguable. In fact, the courts had to stop Mr. Milimo many times and was lenient to many others of my colleagues who strayed into the merits. Prof. Agenda being at the forefront of that. The council argued the merits on both sides of the island. And so, my Lord, that demonstrates that parties are biting at the bits. They are ready to argue the petition and will do so at the earliest opportunity. We request you, my Lord, to allow the request for conservatory orders to please preserve the dispute.